Just search my name in Bill 36 or something, you'll find the Property Rights Institute's put on their website, CAPLA's got it, Legal Education Society's got it, Landowners Against Bills, a whole bunch of websites have posted the paper. It's free, it's there for you to educate yourself. Here's the nasty, Section 11. For the purposes of achieving or maintaining an objective or a policy of a regional plan, a regional plan may, by express reference to a statutory consent or type or class of statutory consent, affect, amend, or extinguish the statutory consent on the terms and conditions of the statutory consent. So what's a statutory consent? Well, that's when you have to go and look at the definition section of the Act. It defines statutory consent as meaning a permit, a license, registration, approval, authorization, disposition, etc., or instrument issued under or authorized by an enactment. Some terminology. We talk about a vehicle, a pickup truck, and a Dodge Ram. They're all the same thing, right? They're just different words to describe them. In the legal world, we refer to an act, an enactment, and a statute, and sometimes legislation. So those are the words we use to mean the same thing. So an enactment is every other act in Alberta. So the Water Act, the Municipal Government Act, the Public Lands Act, the Land Titles Act, the Mines and Minerals Act, etc. So if there's an instrument that by the definition of that other enactment it issues, that's a statutory consent and can be extinguished by Cabinet. So let's have a look at the Land Titles Act. Land Titles Act, Section 1K, defines instrument as a grant or certificate of title, conveyance, a deed, any other document in writing evidencing the title of land. Okay? So an instrument at law, an instrument is a land title. An instrument is issued under an enactment. Well, what was the definition again? A statutory consent means an instrument issued under an enactment. So you see how a land title is now an instrument? Okay? It's very clear. The reason I'm doing that in such detail is the government keeps saying, and they finally put it in writing on Friday, which was a great relief in some respects. They say it's not the Land Stewardship Act can't allow the Cabinet to extinguish a land title because it's not in the definitions. And I just say, you're kidding me. Well, either is a water license, and they've already admitted they want to be able to extinguish those. Neither is a development permit, and they've already said they're prepared to extinguish those. Neither is a well license from the ERCB in this definition. You've got to read the law. That's what us lawyers are trained to do. And so the definition of statutory consent includes a land title. Full stop, crystal clear. Not just me, but many other lawyers have looked at it and said the same thing. So Section 11 gives the Cabinet the legal authority to extinguish your land title. Is anybody else saying this? Am I making all this up? Well, I'm not. There was an Edmonton Journal article where other experts were interviewed, and they had all kinds of comments about it. And the headline was, "Land Development Bill Scary. Critics warn new act will give province unprecedented power." Here's one of the quotes. This is from a person I've never spoken to in my life. Quote, "It's quite a scary bill," close quote, said Laurie Danielson, Executive Director of the Edmonton Area Industrial Group called the Northeast Capital Industrial Association. Quote, "I have never seen a bill anywhere in the country that gives the government as much authority. The bill allows the government to decide whether you exist. It can wipe you out in a heartbeat." Okay? I didn't say that, he did. And I apologize if I appear defensive, because what the MLAs are saying, and they'll have said it to a number of people in this room, and they'll say it to you if you talk to them, "Oh, don't listen to Wilson, he's just making that up." I wish I was just making it up. I'm not. Here's a lawyer, well-known lawyer in Calgary, does about 70% of his work for oil and gas industry and the rest for landowners. Gavin Fitch, who specializes in energy and environmental law, is alarmed that the bill gives Cabinet, quote, "complete and unfettered discretion to plan development." While the bills call for the creation of a regional advisory committee to oversee development, there's no requirement for Cabinet to establish the committees or to follow their advice, he said. Fitch said prohibiting appeals to the court is, quote, just wrong, close quote. So what's he talking about? Well, this is like a funny question on a social studies high school 12 exam. Look at this. Binding nature regional plan, section 15 sub 1. Except to the extent the regional plan provides otherwise, a regional plan binds A, the Crown, that means the government of Alberta, B, local government bodies, so all your local municipalities, C, decision makers, that's defined in the Act as including any governmental decision maker, so the director at Alberta Environment who allocates water licenses, the NRCB, the ERCB, the Alberta Utilities Commission, the Surface Rights Board, the Land Compensation Board, you know, people in the Alberta government who authorize things. They're all considered to be decision makers at law under the definition. And D, all other persons. So this is binding on the provincial government, local governments, decision makers, and all other persons. Who did they miss? Nobody. They could have saved a lot of ink and just said the regional plan binds everyone, because it does. 12. This shows you how far it goes. A regional plan, so this is the cabinet's the only one who can approve and amend a regional plan. A cabinet plan may manage an activity, which is defined as to mean anything, literally, by definition, an effect, a cause or effect, or a person outside a planning region until a regional plan comes into force with respect to that matter or person. So they can even not just manage the land or the use or your water, but actually a person. And of course a person at law includes a corporation or an individual. Their words, right in the Act. Here's the compensation section. No compensation if rights are extinguished. Section 19, no person has a right to compensation by reason of this Act, a regulation under this Act, a regional plan, or anything done or under a regional plan. So if they take away your rights or impact on your business through a regional plan, the rights you have today to seek compensation are removed by virtue of this section and some other sections, okay? Now you'll notice up here, there's those who can see it, there's 3 little dots. That means there's some words I've left out. And what some of the MLAs are saying, oh, but he's leaving words out. And I'll show you in a minute why. The bottom line is there is 2 subsections below this. I analyzed them the first time I read it, hoping that I would see that it would give you compensation. And neither of the sections that are below this, where the dots are, give you compensation if the government uses its powers under Section 11 to extinguish your existing rights. This is this wording for, unless there's a lawyer in the room, won't mean much to anybody, but let me explain what it means. They say regional plan is the expression of the public policy of the government of Alberta and therefore the Lieutenant Governor and Council. Lieutenant Governor and Council's fancy words for the Cabinet. That's what the Cabinet's called at law, is Lieutenant Governor and Council. Has the exclusive and final jurisdiction over its contents. I was speaking with the Senior Litigation Counsel from Ontario before Christmas for the Canadian Constitution Foundation. And she said to me that when she looked at this wording and a bunch of other sections, that she had never before seen a piece of legislation that was so carefully drafted to avoid the words that the courts have said in court cases trigger a government's obligation to pay compensation. Now there's court cases where people have felt hard done by, and the courts looked at it and said, well, the government used these words, therefore the person gets compensation. Another case a little while later, the court looked at it and said, well, the government used these different words, therefore no compensation. The wording of the legislation, by the drafters at least, was carefully designed to prevent you from getting compensation. And I've done a number of extensive, detailed, legal written analysis to show why that is the result. I'm not happy about it. When I started my analysis, remember this, it's better for me to get to the end of it and find out you got compensation. I wasn't hoping for this to be bad. I was hoping that, you know, and I thought, okay, well maybe 19 sub A will solve the problem. And I read it and I go, doesn't do anything. And then sub B, doesn't do anything. So anyway, this does is make sure that the courts can't intervene, but they go further. Section 15